Action People's Party has prayed a federal high court in Abuja to nullify the election victory of the party's candidate in the Rivers local government election held on October 5. The plaintiff, Juboye Abraham, in a suit marked FHC/ABJ/CS/1464/2024, filed by his lawyer, Obai Okairo, urged Justice Binta Yako to make an order setting aside the candidacy of the APP in the election. He also prayed the court to nullify all the votes cast for the state's local government chairman on the APP platform for being in breach of Section 225 subsection A of the 1999 Constitution as amended and the Rivers local government law. ATL reports that in the suit dated and filed on October 4, Abraham sued the Independent National Electoral Commission, APP, and Rivers State Independent Electoral Commission as the first to third defendants in the suit. He also joined the elected local government chairman as the 15th to 26th defendants, respectively. Abraham is seeking a declaration that it is illegal, unconstitutional, and void for INEC to continue to keep APP in the register of political parties in Nigeria when it is manifest that the party is in breach of Section 225A of the 1999 Constitution. He sought an order compelling or directing INEC to exercise its powers under Section 225A of the 1999 Constitution to register APP as a political party registered in Nigeria with powers to field candidates in any election having been in breach of the law. He also sought an order of perpetual injunction restraining the RISIEC from placing APP logo on the ballots for October 5 Rivers local government election, having been in breach of Section 226A of the 1999 Constitution. Abraham further sought an order setting aside the candidacy of the 4th to the 26th defendants in the said election and nullifying all the votes cast for them being in breach of Section 226A of the 1999 Constitution and Rivers State local government law. When the matter came up before Justice Nyako, Carlo Agu, who appeared for the plaintiff, informed that all the defendants had been served and the matter was slated for mention. When the judge asked him what the subject matter of the case was all about, he said the rest is about the non-performance of the statutory responsibility of the first defendant, being INEC. Counsel for APP, Obed Ago, said though they were yet to file any application, they intend to respond to the plaintiff's suit. Obed also told the court that the INEC lawyer was in court but stepped out before the proceeding commenced. The judge consequently adjourned the matter until February 5 for hearing. She ordered that hearing notices be issued and served on defendants who were not represented in court. Honorable Don, you are a legal practitioner. You are here specifically because of this particular story. What is your take on this development?
Anyways, good morning, Nigerians. Well, from the position read so far, first of all, we have to understand it's a constitutional issue. It is a matter that has to do with the holding of the sanctity of the Constitution. Like you had the plaintiff who was in court to request that the court gives life to the provisions of Section 225 as well as 225 paragraph subsection 1A, as much as Section 226 subsection 1 and 2 of the Constitution of the Federal Republic of Nigeria as currently amended in 2023. Now, what is the purpose of that provision? That provision is of the fact that the Independent National Electoral Commission shall have power to deregister any political party who is unable to score 25% of its total vote in any state of the Federation that has to do with the election of the President of the Federal Republic, any state of the Federation, there's any local government in a state that is unable to score 25%, for a governorship election, any local government chairman election, any, ward in a local government that's supposed to score 25% in a ward. And then when you go to the councillorship election, it applies in the same way. And that where the party cannot also secure one seat of the National Assembly, including the seat of the House of Assembly, in that general election, the INEC is empowered after that process to deregister that political party. That is what the plaintiff has gone to court. And the matter is instituted by originating someone, asking the court to interpret and give effect to that provision. So for me, it is a good suit. For me, it is a suit, that has to do with public policy, because anything that has to do with the provisions of the Constitution has to do with the public, because the effect obviously goes back to the public. So the plaintiff going to seek the court's attention to implement or give pronouncement to these provisions is not a step in the wrong direction. I feel it is a step in the right direction. And then going further, we have seen that this same party, which is not known, in fact, it was when they started advertising the issue of local government, whatever election that they called it, that I knew about APP. APP, in fact, is a far long gone party. It's a far long gone party. It's not a party that has activities within the country. We don't even know when they do congresses. We don't even see them, not to talk more in the state, like Rivers State. We don't even see them hold their political meetings, just like PDP, APC, and Labour Party has been doing. So, obviously, once a party is formed, it's no longer a private affair. You understand? Their organization, their activities is supposed to be something that the public will know about, because it is not a secret court. So since it's not a secret court, that's the difference between a secret court and a political party or a political association, if you go under the Constitution. So since they are unable to provide these constitutional provisions, you understand, it is the duty of the court to make pronouncement of the sanctity of that of their existence. And going further, this suit was instituted before the election, October 5th.
October 5th, local government election.
Local government, so-called local government election, because I don't consider it as a local government election. With all respect, I have my reasons. So now, this suit was instituted, and the matter is still before the court, pending. And again, the plaintiff has told us, he said, the mode of the election of the chairman of the parties, I hope you understand, as well as the election of the local government, possibly in Rivers State. These are issues that are before the courts. So look at the issues there. When did they form? When was Congress held? When was these people, when were they adopted as party members? I hope you understand. And then when their dues and registration, how long have they been paid?
But this is not, these questions now, it's not part of this current prayer.
No, what the plaintiff is telling the court to do is to nullify the elections. These are the issues that the affidavits...
Is it to nullify the elections by empowering INEC to deregister APP?
Nullifying the election is one prayer.
All right.
Asking INEC to deregister is another prayer.
Okay.
Now, but the flesh to these issues will be contained on the face of the affidavit in support. All right. Okay, of the originating prayers. Do you get it? So what the plaintiff is asking the court to do is to look at Section 225. Section 225 has made clear provisions as to how or the conditions a party, must fulfill for it to continue to exist. If this party cannot fulfill this constitutional provision, it means this party too should not exist, because, by all intent and purposes, they are not meant to exist. I hope you understand. Because they are unable to fulfill this condition.
So in the first instance, the party was not qualified to even field candidates for the local government election. Is that what you're saying?
Exactly.
So going by the prayers of this person, the prayers is that that APP originally should have been deregistered
before the October 5th election. That's the point, because that's the point, because INEC, after the general election, I hope you understand.
Yes,
after the general election, it was enough to show that APP, not just APP, maybe other parties as well, you understand, who are unable to muzzle, at least to fulfill the constitutional provision of section 225A, didn't need, court order for them to be deregistered. INEC, by that provision of section 225A, okay, by subsection 1 of that provision, had the power to deregister them. How do you deregister them? By no longer allowing them to exist or putting their logos on the register of political parties. I hope you understand.
Ballot box, the ballot paper.
Ballot papers and register of political parties.
Okay.
Their logos are no longer supposed to be there. Not just APP, but other parties. I see there is one party they call Broom Party. There are some these mushroom parties all around. You understand? And because, sometimes they feel that because there is a room for association, people just come together, form what they like. Political party is mainly form for the winning election. Okay, that's their most primary function. They are not formed to do party. They are not formed to carry out fund and pageantry. No, so they are mainly involved, required to win election. So, in view of the fact that they cannot win any seat in that election, then what it means that the INEC is supposed to deregister them. Now, furthermore, in the October 5 election, so-called local government election that was carried out in this state, honestly, that election was cut down, okay, by the provisions of this constitution. That election was cut down by provision. If you go to section 226 of this constitution, it makes provision that every political party must make ready and submit its sources of revenue, sources of funding, you understand, to INEC. The question is, who was funding the APP election in Rivers State? Who was funding the APP election in Rivers State? It's a notorious fact. The governor was funding it.
That's an allegation.
We can call it an allegation.
That you are making an allegation.
Yes, you can agree that's an allegation.
That's an allegation. Can you substantiate that?
Now,
can you provide the statement of account? Can you speak? Can you say that this is the amount that the governor funded the party with? If you cannot substantiate these things on national television, it's an allegation. Don't you agree?
Now, see, whether you like it or not, that is an allegation or not, without the governor's effort in Rivers State, APP is not a party known. You and me know. Without the governor's effort in Rivers State, where we are the party before the governor came into power, it was the governor that brainchild this whole thing. That brainchild this whole thing, and then initiated the processes that led. The allegiance, as we speak today, is all to the governor of Rivers State. They can't lie against it. They can't deny it. APP's allegiance in Rivers State is all to the governor of Rivers State. Okay. Without the governor, APP is nowhere in Rivers State.
All right,
so that goes to further tell you of the issue of source of funding of the party.
All right, very well. Let us look at the 7 questions that the plaintiff asked the court or sought for answers from the court. It says, let me go through it very quickly. He said, whether by virtue, the first one is, whether by virtue of Section 225A of the 1999 Constitution of the Federal Republic of Nigeria as amended, the first defendant, that is INEC, has the virus to deregister political parties that are in breach of the provisions of Section 225A of the 1999 Constitution. He now said, if the answer to the question 1 is in affirmative, That is, if INEC has the power to deregister parties. If the question is in affirmative, then whether INEC can deregister the second defendant, which is in breach of Section 225A of the 1999 Constitution of the Federal Republic of Nigeria. He now said, if the answer to question 2 is in affirmative, whether the first defendant, in this instance, whether INEC can continue to accord APP, the second defendant, the status and privilege of a political party. And he now said, if the answer to question 3 is in the negative, whether the second defendant, that is, whether APP can function as a political party. This appears to be rhetorical questions because he was already answering them. Then he now said, if the answer to questions 5, okay, sorry, is October 5 elections in Rivers State, if the answer to question 5 is in the negative, whether the third defendant, that is RISIEC, can place the logo of the second defendant, APP, on the ballots for October 5 Rivers State local government election. And if the answers to question 5 and 6 are in the negative, whether the court ought to make an order nullifying the standing of the 4th to 26th defendants as candidates in the local government election and setting aside any benefit or privilege. This matter appears to be a lot is attached to it. Because now, apart from nullifying the elections and ordering INEC to deregister APP, it's also praying that the 4th to 26th defendants be disqualified as candidates of the APP.
Yeah, let me throw more light. See,
yes, go ahead.
This is a constitutional matter. And the plaintiff is simply bringing out all the indices, things that has happened within the period that
is in breach of the Constitution.
That the suit was filed, and those that happened, you know, when this action took place.
Okay.
Those indices is what the court, what the plaintiff has brought before the court. The plaintiff election, the general election have passed. The party, their own party, APP, did not win one single seat, even as councillor. Ramesh, I hope you understand.
I understand.
Even as councillor, they didn't win one single seat. And then they looked at it. Is there any reason to continue to pay our dues in this party? Is there any reason for us to continue to contribute money to pay house rent and pay this and pay that we are in a political party where we can't even win one seat? Why do we have to waste this time? Why don't we just ask INEC to deregister us so that we can go our way? Now, while that conception was on, the Rivers State government, by way of alignment or realignment, aligned with the All Progress APP, and then they conducted election that almost all the so-called APP candidates won. And the governor of Rivers State was happy, congratulated.
There was an exception. A local government. I think it was Eche.
Eche, yeah. I say almost. I didn't say all. Won. And the governor was happy that all his boys, lieutenants, were the ones that were giving tickets in the election. That party, as at the period that they conducted that election, this matter,
it's a
APP
matter.
The APP had not won one seat. Okay. To continue to keep them floating, for them to be used as a vehicle to conduct that October 5th election. Do you understand? So beyond the issue, it's a pre-election matter. It's not a post-election matter. If it was a post-election matter, then we'll be talking of the plaintiff going to the tribunals. And of course, going to the tribunals, there are certain conditions, of course, you have to fulfill. Now, going beyond that, the question the plaintiff will seek is already already with deposing his affidavit, is also showed too that these persons are not even members of the APP before the election. I hope you understand. These are not members, registered members of the APP.
Can a political party give waiver?
Now, waiver.
And where does waiver apply?
Now waiver can be given, but you know, the Constitution, the Electoral Act provides certain guidelines where waiver can be given. This is not the issue of waiver. The suit before the court is not the issue of waiver. The suit before the court is to ask the court to instruct or order INEC to do what it is called in order of mandamus. To perform the order of mandamus, a public institution that is supposed to carry out a specific action. Failure to carry out the specific action, in fact, what in law, what the plaintiff has gone to do is to ask her to order this mandamus on INEC, asking them to do what they are supposed to do as a body, you know, giving responsibility to manage, control, manage, and supervise election. You understand? And political parties affairs in Nigeria. So APP was registered so it could win a seat or election. Unfortunately, they could not win a seat in an election.
The thing is, at the national level, National Assembly, they don't have one candidate.
Not even councillor as at when the general election was held. So, do you understand?
Yes. So, and they did not win 25% at any
level. Not even a seat.
And at the national level, they didn't win any seat.
They didn't win anything. The only party that won was YPP with late Senator Ifeanyi Ubah. You know, the YPP candidate from Anambra Central. You understand? That was the only party, of course, I can remember that won election in this 2023 election. APP didn't win any election. You understand? So on that basis, INEC ought to deregister them. That's what the plaintiff is going to court to do, or asking the court to do, to make an order of mandamus on them. Now, obviously, the truth is that if the court agrees with the plaintiff, it means that the party, once it is deregistered, it can no longer be a vehicle for anybody to use. Not even the so-called local government election that was conducted. I hope you understand.
So in this instance, if the party is deregistered, it means that this local government chairman automatically...
If the relief sought are granted by the court,
the local government elections...
obviously, in the eyes of even the law, I don't even see them as local government chairman.
Now, at this point, in River State crisis, it appears that this River State crisis is not ending anytime soon. I mean, because the fight has been, I mean, the 2024 budget is under litigation. The appeal court judgment has held that the governor is in gross violation, and also held that the governor is in contempt of court. On the other hand, the River State lawmakers are battling with survival right now because of the alleged defection. And the matter also is in court. So now the executive has his own troubles. The River State House of Assembly has its own troubles. And now this is trickling down to the local government. How do you see this playing out? It appears that the River State crisis may not, at this point, I don't think I should be asking what is the way out. I should be asking what the implication of all these things will be on River State.
Let me break it. You see, I was on this show sometimes and I said, I use this show to appeal and advise the governor of River State. I said, any action, you can remember I said, any action taken by any of the parties will have a gross effect on the people of River State. No doubt the problem is not doing any good to the state. I must tell you, the problem is not doing any good to the state, because obviously a lot of people who are not in the political class are suffering because of this seemingly unnecessary animosity, okay, that is being demonstrated by the actors. And I said the governor should understand that he steers the government of the state in that class. The government of Rivers State is headed by him. And he must be conscious to understand that it is this constitution that brought him to power. So anything that he is doing, he must do things in consonance with the provisions of the constitution. Part of the problem in this state is because there is a gross disobedience of the provision of the constitution. I'm not even talking about the FCT minister. Is the FCT minister the governor of Rivers State? No. It's the governor we are talking about. The actions of the governor or those around the governor. That's the problem. If the governor follows the provisions of this constitution, I don't think there will be a problem. Now, let me even tell you. Look at even the Rivers State Independent Electoral Law, okay, that RISEC, consolidated before they gave, before they fixed date for the so-called October 5th election. Section 13, subsection 4 of that law says RISEC will be able, should have power. The RISEC will give notice of 3 months, okay, before the expiration of the tenure, okay, of the local government administration that will want to expire. I hope you understand. Sorry, 3 months to the date of the election, okay, of the local government election, and that there must have existed a vacancy in the election or in the seat that they intend to conduct election to fill. That's what section 13 subsection 4 says. Are you going to the elongation of local government chairman tenure? Is that where you're going to? See, that you just made mention of the issues, crisis, that is befalling the state and the impact. And so I am responding in view of that question. Now, that issue that, the conducting of that election in view of an extension of tenure of the local government administration is part of the problem that we are facing. Now, that is a concern. The House of Assembly extended the tenure. And as at then, we must be very, let us be very liberal here. As at when the House extended the tenure or made intention or made a notice that they were going to extend the tenure of the local government chairman, these issues are not really started. The issues are not really started. Now, to their notice, they knew the House was resolved to make an extension of this tenure for 6 months. It was after then people started going to court. So there was an extension by resolution of the House.
So in your opinion,
so there was no vacancy, as at the October 5th to conduct. There was no vacancy. There was a 6 months extension. There was no vacancy. Tenure ordinarily expired by June 18th. Okay? June, July, August, September, October. It's about 4 months. 4 months and about 14 days. Do you get it? Tenure extension was still on. And then you conducted the election. That is in breach of that section 13, subsection 4 of the same Rivers State Independent Electoral Law number 2.
So in this instance, the ousted or outgone local government chairman, why are they not
outgone? You can't call them outgone.
Hold on. For now, are they occupying the secretariat?
Who is occupying the secretariat? These current the people that are parading, are they occupying the secretariat?
Let's not mix things up. So we
are not. But I'm just trying to talk about the crisis.
Confuse our viewers. they are not currently occupying the secretariat. The FAC allocation, the local government allocation, is not going to them.
You can call them embattled, but not outgone.
Embattled.
Because
okay,
matters
let's use the word embattled. Now, that's actually where I was headed to. Have they taken this matter to court?
Who?
The embattled local government chairman.
Of course, matters are in court. Of course, I mean, a lot of matters are in court, touching on the subject matter.
Now, I am talking of not individuals here, but the embattled chairmen themselves.
The matters are covered. Of course, the local government chairman, the chairman have gone to court. They are in court. And then the matters are even covered by, there's a matter currently at the Supreme Court that Victor Okojombo and the governor, with respect to his Excellency, has appealed. In that appeal, that extension is there. I hope you
Actually, there is a Supreme Court judgment. I thought you would be making reference to the local government autonomy, the Supreme Court judgment in the local government autonomy, because the
local government autonomy judgment...
When the Supreme Court was giving judgment on the local government autonomy, people were thinking it was just the financial autonomy. There were also other aspects of local government governance
saying
that the
House
Supreme
of
Court
Assembly
judgment, that the Supreme Court judgment touched upon. And one of it was elongation of tenure.
Yes.
Where that was paragraph 16.
Yes.
I think page 16.
Yes.
It was on page 16 of that Supreme Court judgment, where the Supreme Court was saying that the House of Assembly has powers to extend the tenure of local government chairmen by a period not exceeding 6 months.
Yes.
And they went further to say that it can only be done when it is impossible to for elections to hold. That the House of Assembly of a state can extend the tenure of local government chairmen. And he said that if the tenure of this local government chairmen are being extended, it is the mandate of the people that is being extended. But if it is being truncated, it is the mandate of the people that is being truncated. So now when you're saying that it's also in Supreme Court, Supreme Court had given a judgment prior to this time.
No. What I mean is this. The Supreme Court appeal I mean is there's an appeal that Justice James Omotoso's Court of
it's in Supreme Court, the first appeal court judgment, because there are two appeal court judgments. The suit was appealed. Okay. Yes, Justice Okorowo's judgment, Justice James Omotosho. James Omotoso's judgment has been appealed to Court of Appeal. Motion for stay was, set aside. It was rejected rather. Okay. Now they appealed that judgment to the Supreme Court. Obviously, I'm not expecting anything different from what the Court of Appeal have done, because there is no evidence. The court keep consistently mentioning that there was no evidence. Number two, that the court that even handled the matter here, that's Justice Wali's court, that other matter that was appealed, had no jurisdiction. The court cannot also... Wali's court, the injunction to vacate that vacated the seats of Martin Samuel.
Yes, all those. And you know that the matter was, by virtue of that appeal, that proceeding died a natural death here. They couldn't conclude the proceeding here. So, as we speak today, the Speaker of Rivers State House of Assembly is Right Honorable Chike Martin Samuel.
All right.